excited to want to have an attorney here at our disposal, right? As an agent, I've been threatened. Actually, most of the suing that I've been threatened with, it's actually, when I'm representing the sellers by the actual buyer trying to sue the seller to get out of the deposit. That's to get their deposit back. That's the biggest one I've seen, but you never know, right? As you go through your career, what can happen, and we definitely want to protect ourselves. So excited for this webinar.
Well, that's a really good point. And there's like a bunch of there's a bunch of rules and stuff we can go over, but the things I try to come up with, the things that I came up with are the practical things that realtors face on a regular basis. So you can hear about a lot of stuff. There's a lot of information in the ether, but the stuff I focus on with you guys, it's all practical stuff that I see in real life. And the stuff that we go over is going to all have practical applications from, I hate to say it out loud, 30 years of talking to realtors during my career.
There's a lot of realtors, I'm sure you've
A
seen.
lot of realtors and a lot of time.
Yeah.
But it's all good. And when I say iron sharpens iron, I mean it legit. Like everything that I learned, people call me, and the first thing realtors say when they call me is, I'm so sorry to bother you. And the first thing I always say is, I'm so glad you bothered me. I'm so glad you called me, because now I've got valuable stuff that we can share with all the other agents. Let's see. Do you want to be able to paste the last item you copied from Microsoft Outlook? No. All right. So without further ado, Ryan, why don't you do the big intros?
Yeah. No, we're excited to have you all here. This is our bi-weekly webinar. Jim and I host this. We're excited to do it. A little bit background about myself. I'm a real estate agent, just like you, in the trenches. Been doing this for over 20 years. Love the industry. And then a little over 2 years ago, I started a real estate tech company called RealTrade, which is an online real estate marketplace, a social media platform for real estate. It's an amazing platform, if I do say so myself. It's a great way for agents to get buyers and sellers. Cool thing is it's free for agents. So kind of the cool thing on RealTrade is you can make a profile, and buyers and sellers can contact you and connect directly from your listings. So as Jim likes to say, we're the home of the double dip. But my co-host Jim, can't say enough great things about him. He's an awesome real estate attorney, owns a great title company called New Path Title, and an awesome closing software called Title Leap, and which is amazing. It's like a contract coordinator. So, and our big thing here is we want to add value to the agent community that we've created. We have over 1,700 agents on RealTrade, a lot here using Title Leap software. So Jim, why don't you do a quick intro for yourself too?
Now that's what we're all about, Ryan, right? I'm a lifer in this industry. You're a lifer in this industry. We're all about raising the bar for everybody. So we bring products to the market, Title Advance, Title Leap. You guys, I learned invaluable information that we can share with other agents and make everybody stronger. We're going to try to keep this thing to about 30 or 45 minutes of the topic. If you turn on your camera and I can see your reactions, it helps me a lot, because then I know if I'm over explaining or under explaining. If you're not comfortable with your camera on, that's absolutely fine. There'll be a question and answer session at the end. We have a small group today, so if anybody wants to chime in during the group, I'd love to hear your feedback. Ryan, if you can watch the chat, yep, that'd be great.
Yep.
Most importantly, if you guys have questions for the future, I shouldn't say most importantly, but if you have questions for the future topics you'd like us to cover, I'd be more than happy to research and cover those topics. And anytime you need to text me or call me 24/7 in between this session and the next time we get together, don't hesitate to do that. At the very end of this session, we'll have our question and answer, and Ryan will go over some really great tools that he's providing through RealTrade, and I'll go over some really great time-saving tools that we're providing through Title Leap. There is no bad question, and the topic we're going to go on today, it's kind of it's kind of technical, and I don't want anybody to feel like overwhelmed or stressed out. I want to impress upon you guys, right? The most important thing isn't that you know the rule. The most important thing for a realtor is that they know when there's an issue, right? So I always say to the agents that we work with, there's always a rule for something. You don't necessarily have to know what that rule is. As long as you know that there's an issue, then you can text me and I can call you back and we can figure out the rule. Or hopefully I've given you enough tools that you can go out and find the rule on your own. And all the rules that we operate under live in one of a couple of places. The first is the contract.
Yep.
The second is the realtor's code of conduct, and well, that's probably the last one. So you have the contract, which is the first, then you have state law, and then you have case law, and then the realtor's code of conduct. And if you stick within that framework and you think about these things, it's not a mystery as to why people do what they do when they do it. Let's see what we got here. I want to start off with this screen here. All right. So the name of this topic that we're covering today is, what's this screen I'm looking at now? You guys see my screen, how realtors don't get sued, Ryan?
Yep. We can see it clear.
All right. So the name of this topic today is, quite plainly, how realtors don't get sued. And there's a couple different topics we can talk about, right? There's suits from one realtor against another, and there are suits against buyers and sellers against realtors. These suits are going to be specifically what we're talking about today is when buyers and sellers want to sue their realtor. And I get the calls, it's disheartening to me. I get the calls from the buyers and the sellers, and they say, "Oh, I want to sue my realtor. This is what they did." And those are very uncomfortable calls, and 99% of the time, there is no, what we call in the business cause of action. But every once in a while, you'll get somebody that calls, and they'll have a legitimate issue that they can sue their agent over, and it usually stems from one of two fact patterns. The agent either said something they weren't supposed to say, or they didn't say something when there was a duty. So 99% of all the suits boils down to communication. Know what to look for, what to say, and when to say it. There are only a couple of general rules and a lot of common sense. The safe rule of thumb is if you know it and your buyer or seller is going to feel bad if you don't say it or you say it wrong, then almost always saying it is the better bet. Very, very few exceptions to that. That's just common sense, right? I get a lot of agents that'll call me and they'll say, "But if I tell my client this, then it's gonna twist them to do that." And if you think about it, right? If you tell them now, it'll probably cut off that call in the future where they're upset, and then you're gonna foreclose that whole issue. I heard an interesting fact, and so generally realtors don't have a duty to disclose so in general, we're going to get into this more specifically, but in general, a realtor does not have a duty to disclose facts that hurt a property if it's in the public record, or it's a generally known fact in the media or the law, or a reasonable inspection would discover it.
Johnson v. Davis.
Johnson v. Davis, Ryan. Oh my God, I'm so proud.
You've hammered it.
I've schooled some agents, right? I worked with them since they were leasing agents 15 years ago, just barely making enough money to pay the bills. And now one of the guys that I've been tutoring since he was started is now one of the top agents in Palm Beach County. I think he was the top listing agent a year or so ago. All right. I heard an interesting set of facts, and this is just something to think about, right? As we go through all these disclosure issues. I heard an interesting set of facts, and to be completely honest, I didn't have a great answer. So I want to share the set of facts with you, and it just makes for a great topic to discuss. So a realtor lists a condo on the 3rd floor of a 10-story building. A few months earlier in that unit, a bullet came through the bathroom window, embedded itself in the shower wall. The seller fixed the shower so it was not detectable. The bullet was fired by a shooter in the neighborhood where drive-by shootings were not previously frequent. So don't come up with an answer. It's just something to think about, right? So you got this neighborhood where things don't usually happen like this, and you've got something that clearly is out of the ordinary, and you've got a seller that has knowledge, and you're not going to find it in a normal inspection. So that's kind of like the framework to think about. When can someone sue? We've all heard somebody say, "Oh, anybody can sue anybody for anything, anytime," right? Everybody said that. The reality is, yes, anybody with a few $100 in their pocket can draft a complaint without a lawyer And when I say without a lawyer, provided there are no corporations, if there's a corporation involved, you can't do it yourself. But let's just say anybody can at any time draft a complaint and file it with the clerk of the courts and start a lawsuit. It's expensive, and the person you're suing, if you have if you have a baseless cause of action, they have some great remedies against you, and it's going to get expensive. So it's true, but that's not necessarily the end of the story, right? Anybody can sue anybody for anything, anytime. But I can tell you personal experiences where I know a lawyer that filed a suit where the judge said it was a baseless suit, and now the lawyer owes 30 grand, the law firm owes 30 grand, I mean, the whole thing's going to be $100,000 before they're done because the lawsuit was baseless. So in the realtor space, a proper lawsuit would almost always be called a tort. A tort has three elements. All must be present for a successful suit. So Ryan recanted the Johnson v. Davis test, which is when does a seller need to disclose. You don't need to memorize what a tort is, but when I get panic calls from realtors, if you think about when can somebody sue, right? There has to be three things present. There has to be a duty, there has to be a breach of that duty, and there has to be damages. It's not enough that you had to do it, that there was something you had to do and you didn't do it. If there's no damages, there's no lawsuit. And anybody that brings a lawsuit without damages is going to be baseless, and that's going to fall into the category we just talked about. So what's a duty? The duty comes from, like we talked about at the onset, a law or statute setting out what the realtor's behavior should be, right? So usually that's going to be in the contract, the listing agreement. The purchase and sale agreement doesn't have a lot of duties for realtors, right? The purchase and sale agreement actually says at the end of the agreement, buyers and sellers, if you didn't understand any element of this contract, you went out and got a lawyer and the lawyer explained it to you. By signing here, you're agreeing that you understood every element of the contract. So that sets forth the duty, right? The laws, the listing agreement, your policies with your brokerage, the rules within your brokerage, the listing agreement, the statutes. There's a whole statutory section you guys studied in real estate school that sets out your duties. The breach of the duty is simple. You did the thing that you weren't supposed to do, or you didn't say the thing you were supposed to say, right? That's the breach. And then damages. If there's no damages, there's no financial losses, there's going to be no cause of action, there's going to be no lawsuit. That's a baseless claim. So we're only talking about civil law in this outline. We're not talking about criminal law. And the only remedy in civil law is what? Money.
Money.
You'll never go to jail for a civil penalty, a civil issue, a tort issue. Now, if you do something that's so egregious, it could rise to be criminal, like you misrepresented something and there's fraud and things like that, then it could
Stolen escrow deposit.
What's that?
Yeah, it's like stolen escrow deposit, you know?
There you go. I have a broker that called me the other day. Good point, Ryan. The realtor's running around and collecting escrows on rentals and purchase and sales, and they're nowhere to be found. And the contracts aren't in the hands of a title company, and that's criminal. That's gonna go beyond civil. But right now, we're only talking about civil. So if you don't do anything that you know is really, 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 really wrong, then we're probably in the civil world, not in the criminal field. So two most popular claims by buyers and sellers against realtors: disclosure failures and fiduciary duty breaches. We'll go over both of them, but the disclosure failures are by far and away the biggest source of exposure for realtors. And when I say exposure, I'm talking about being the defendant in a lawsuit. You got a plaintiff that's going to be a buyer or a seller, and you got a defendant that's going to be the realtor.
So you're saying, Jim, this is the one thing for agents, right? If they're trying to avoid being sued, is have the proper disclosures, and you're going to go through them, obviously, through this outline. But this is the number one thing that you see where agents have the biggest exposure.
Correct.
Okay.
Disclosure duties, and then failing to disclose. So, and think about it, right? Whenever you're talking about a lawsuit, you want to come back to duty, breach, and damages, right? There was a duty to act, and again, you don't have to memorize it, but if realtors call me all the time and they'll say, well, did you have a duty, right? And so the one I get all the time is the realtor calls me up and the realtor says, oh my God, I forgot to remind my buyer about the inspection period end. And does the realtor have a duty to tell the buyer the inspection period ended? No. Do they do it because they want to get their commission and it's the proper thing to do and it's the best practice and it's the best professionalism that they can display? Yes. But do they have a duty to tell the buyer that the inspection period is ending? They do not have a duty. The buyer has a duty to know what the contract says.
Got it.
The buyer has a duty to know what the contract obligates them to. And I hear it all the time. Oh, my realtor didn't tell me I didn't get my loan. Oh, my realtor didn't tell me that my inspection period ended. Oh, my realtor didn't tell me that my deposit went hard. That is not the realtor's duty, right? So you can't get sued for that. You can get sued for other things that we're going to go over, but that is not a realtor's duty. It's probably worthwhile to bring up the contract and just look at it real quick.
I will say this, after using, Title Leap with the drop dead dates, Jim, it's amazing, especially when the buyers can sign in and view all of them too in real time as well.
Yeah, you see all that stuff firsthand.
Yeah. All right.
As it happens and as it unfolds, right? And buyers and sellers agents call me all the time and they go, oh my God, I totally forgot about the inspection period. And then I got the reminder in Title Leap and it saved me so much. I'll never close with anybody but you. I love that stuff. So here is why realtors aren't under a duty. This paragraph right here, this is intended to be a legally binding contract. If not fully understood, seek the advice of an attorney prior to signing. If not fully understood. So if it's fully understood,
they're signing that it's fully understood.
Realtor to tell you what it says. And if it says the inspection period ends Tuesday, then you can't call your realtor on Wednesday and say, oh my God, you forgot to tell me this, I'm going to sue you. And I have had buyers and sellers call me and say, the realtor didn't tell me this and I'm going to sue them. Doesn't fly. All right. Stop screen share. Screen share. We'll go back. Oh, while I'm on that page, let's go over one more thing that we're going to go over. I'm going to, in a few minutes, I'm going to go over the Johnson v. Davis test, which Ryan pulled out of the bag early on. Thank you, Ryan. And the Johnson v. Davis test is in the contract. So if anybody ever forgets it, there's no excuse. There's a section in the contract called disclosures. And so the topic that we're talking about is disclosures, and there's a section in the contract called disclosures. You can see my contract form, Ryan.
Yep. Yep.
And then here under disclosures, in the very last paragraph, which you might think would be the first paragraph, there is the Johnson v. Davis test. Sellers know of no facts. There's the first element. Materially affecting value. There's the second element, which are not readily observable. There's the third element. It also appears at the top of the seller's disclosure form. If your broker requires that you use a seller's disclosure form, the Johnson v. Davis test is right on the top of the form, but it is in the contract on line 250. Don't forget about that. All right.
No, the seller's disclosure is a lot of, exposure for agents, right? Let me ask you, Jim, I've been a listing agent for a long time and, I've worked with a lot of investors and they do not want to sign the seller disclosure. And then mostly their thing is like, if the buyer's agent has forced me to do one, right? Simply what the investor goes, hey, I never lived in the house. I know nothing about this. I bought it, never lived in it. Right. I don't know anything. It's up to you to do your inspection. You're not required by law to do a seller's disclosure.
No. So California has a seller's disclosure law, and a couple of states have a seller's disclosure law. And people think that if somebody makes a full price offer, they have to accept the offer. Agents are under that misguided knowledge sometimes. And the reality is there's so many elements to a contract that even if they give you a full listing price, there are so many elements to the contract, the seller could say, well, I didn't like the offer for this other reason. And one of them could be a seller's disclosure. A seller's disclosure is a point of negotiation. Now, many agents work for a broker that says you got to use a seller's disclosure, but a seller's disclosure, if not required by the broker, is a point of negotiation. And it's still, if your buyer's agent says, if your buyer's broker says you got to have a seller's disclosure in all your transactions, and the seller's agent and the seller's not willing to give one, there's nothing compelling the seller's agent, the seller, to give the seller's disclosure, except for they want to make the deal.
Mhm.
So if you're willing to walk on the deal because you don't want to give a disclosure, then you don't have to give the disclosure.
Yeah. So Wendy just had a quick question since we're on the topic. If a seller never lived in the property and it is recommended that they still fill out a self-disclosure, or is it enough just saying the broker's remarks that the seller never lived in the property?
I mean, if it's sad, if a buyer really wants a seller's disclosure and the seller's insisting they never lived in the property, they're at a standoff.
Yeah. So what I've done, I had literally signed with the seller before seller's disclosure and just wrote on there, just, hey, seller never lived in the property, seller signed it. There you go.
There's a practical, seller has no knowledge, seller never lived in the property. We see that in a lot in estate transactions where the property was in an estate, and we just had one recently where the personal representative, no knowledge of the property. Mom and dad had bought it a couple of years earlier. Kids were all out of state. They had never set foot in the property. So that comes up a lot.
Right.
But from a protection of my standpoint, is it better to protect me to say that they've never lived in the property by filling out a seller's disclosure? Or if I just put it in the broker remarks, does that cover me?
Well, you're going to get so the best place to put it would be in paragraph 20. Seller has never lived in this property. Paragraph 20 of the contract. You can also put it in the broker's remarks. Hopefully that information, it's supposed to technically get to the buyer if it's in the broker's remarks. Does the buyer's agent always convey it? There's like a whole lot of stuff we can talk about. There's rules and then there's practices, right? And the rule is, if it's in the broker's remark, that the buyer's agent conveyed it to the buyer, if it's material to the transaction, right? But do buyers always convey everything in the broker's remarks? No. But if you put it in paragraph 20 of the contract, then you're absolutely covered. Now the buyer is on notice that the seller has never lived in the property. The seller's never. The best use of the term that would be the best would be seller has never occupied the property. Seller has never occupied the property. Seller has no knowledge of the property condition. Now there's nothing that they can come back to you and say you had knowledge over. Now, even if you didn't say that, the fact is the seller did never live there. The seller does have no knowledge. So even if you don't write it, your seller is still covered. You know, it's just, it might be a little bit of baggage to unpack to get to those set of facts. If you put it in the contract in paragraph 20, you're getting it out there right away. Don't even bother asking me anything about the property. I know nothing about it. Not a bad practice. My point simply is, if you fail to do it, if you forget to do it, it's not like you've opened the can of worms for your seller at all. You just haven't. So we talked about disclosures, failures. There's negligent disclosures, right? It's stuff you should have caught if you looked. Those are negligent disclosures. You should have said something and you didn't. I'll give you some examples of that stuff. Failing to disclose, it's stuff you knew and you should have said, but you didn't, right? So the negligence ones are the easiest ones. The failing to disclose ones are the Johnson v. Davis stuff we just talked about. And then the misrepresentations, right? Those are easy. It's stuff you knew and you just said it wrong. Sometimes it's stuff you should have known and you said wrong, right? So there is some duty of agents to know certain things, and I'll give you some examples of those things. So negligent disclosure could be failing to exercise reasonable care in their duties, resulting in financial harm to the buyer or the seller. Here's an example. Think, when can harm result if you don't say something, right? If you don't do your homework, if you don't say something, when can harm result? Think of when harm can result. Example, you're listing a property with a deceased spouse and you've told the seller, the surviving seller, a power of attorney solves the closing signing issues, right? It sounds crazy. I'm sure in this group, we've never even thought of that. A power of attorney dies with the death of the person who signed it, And so that would be a terrible thing to say. And so you're just kind of like going along with the transaction, and they produce the power of attorney, and you've signed the listing agreement, and now you've listed the property, and you should have known something. You should have said, no, that doesn't work, and you didn't. And so here's the problem. Now you're going to be exposed to the buyer. You're going to be exposed to the seller. They've set up false expectations, and you should have said something, but you didn't.
Wow.
Now buyers and sellers have expectations that the closing date, and that closing date can't be achieved. The moral of the story is, I'm going to revise this before I send you guys this outline. It's not necessarily telling the surviving party that they can sell. It's that you failed to tell them they can't sell, right? It's when you're talking about negligent disclosures most of the time, it's because you're not saying something you should have said. You could also say something that's not true. If it's material enough, it could be worse, but let's just leave it at that for now. Moral of the story is, you don't need to know the rules. You just need to know that there's an issue, and then you can find the rule. Remember, you can always text me 24/7. The stuff you guys text me about is the stuff that makes future episodes that make everybody stronger. Tools to use when the issues come up midstream. Generally, addendums solve everything from effective dates to closing dates. You learn something midstream, you put it together in an addendum, you're going to get a little uncomfortable because it's something maybe you should have known early on. But now what have you done? You're representing the seller. You learned of something. You put it in writing. No one can say you didn't advertise it. Your seller can never say you didn't advertise it. I don't even care if you learned later in the transaction that a power of attorney isn't sufficient, right? You put that in an addendum. There's no better way to get yourself out as agents out of trouble than to have addendums to put everybody on notice of specific issues. So you structure an addendum that says, in your cover letter, right? This isn't what your addendum says. Your cover letter says, hey, I just learned that one of the spouses is deceased and they have a power of attorney. And so we're going to have to execute this addendum. And you just have a closing date addendum that says, when the probate court renders a judgment that the property can be sold, we're going to close within 2 weeks of that, 14 days of the rendering of that judgment, to occur no later than October 15th, 2024, so whatever the case may be. Just as a side note, whenever you do an addendum that has an event, you can't leave it like the event plus 2 weeks, the event plus 30 days, the event plus 60 days. You have to have the event plus a time frame, and then if that event doesn't occur, with an outside parameter. If you don't do that and the event doesn't occur, then the contract is illusory and unenforceable.
Yeah.
Does that make sense, Ryan?
Yeah, it does. No, I've seen that before.
All right. Failing to disclose. This is the single biggest issue of realtor liability. It is a straightforward 3-part test. Look at line 250 of the contract, like we looked at a second ago. The disclosures section, right? It calls out in big bold lights. Disclosures section. It's like a runway, in the airport with the guy in the lane lights. And it's the very last section. And so here's the test. It's called Johnson v. Davis. Ryan gets extra credit. Andy made me happy. Here's the test. Seller has knowledge of the defect. The defect materially affects the value of the property, and the defect is not readily observable. Now we'll unpack that a little bit.
And this is mostly for listing agents, guys. If you're representing a seller, obviously, you know what I mean? And you find something out here. And I've had this happen, so.
Well, I hear you when you say that, Ryan, but it also pertains to buyer's agents, right? Because I know buyer's agents who have learned elements on the property and not disclosed. So absolutely, 99% of the time, this is going to be a seller's side issue. And we're going to talk about in a minute where sellers put selling agents in really bad places as a result of this. But let's unpack the bag for a minute. Seller has knowledge of the defect. That's pretty easy. Seller knows that the roofer showed up and the seller said, I want you to fix these leaks. And the roofer said, okay, let me take a look at the roof. They climbed up there, they got down, and they told the seller, you need a new roof. and the seller said, I want you to repair the roof. Right? And so now the seller has knowledge that the roof needs to be replaced. Maybe the seller only owned the house. We had one recently where it was a flipper. Seller owned the house for a year, and the roofer said, this roof is 35 years old at least, or 30 years old at least. It's exceeded its serviceable life and it needs to be replaced. And the seller said, oh, just repair it and we'll call it good, right? So they repaired it and all the obvious happened and it leaked and it was a concealment and all those things because the seller had knowledge. And so here's where people get into trouble. The realtors, the seller says, how's anybody going to know what I know? And it is so easy for a buyer to figure out what a seller knows. Why? Because the buyer goes to an attorney, and for probably less than $2,000, the attorney drafts up a quick lawsuit, a complaint. It's not a complicated complaint. It's certainly under $3,500. And then they send over requests for discovery to the seller. And the first thing they're going to say is, who worked on the property that you know of in the last, 2 years during the period of your ownership? And then they're going to send over to those people request for admissions. Did you ever tell? So the seller is going to list the roofer and the plumber, and especially if they're a flipper, right? They have to list all the people who worked on the property. Then the attorney is going to send over requests for admissions to those people. Did you ever tell the seller that the property needed a roof? The roofer is never going to take a fall for the seller. The roofer is going to say yes. Now, for $3,500 on a $100,000 claim, the buyer knows exactly what the seller knew. And I'm not going to say it's an open and shut case, but it's pretty much a slam dunk at that point. Once you can prove the seller has knowledge. My point simply in this whole thing is proving the seller's knowledge is not a high bar.
So in that case, just real quick, in that case, Jim, I mean, would the buyer then sue the seller then for $100,000 credit to cover the new roof? I mean, is that what happens?
I mean, sometimes you reverse the whole transaction. It just depends. But yeah, I mean, post-closing, it could be them putting a roof on the property. We had one that we litigated for a long period of time, big, beautiful property. And that was the end result. And the seller was a flipper and they were hiding in their foreign country, and it took a little while, but it was an expensive property. We've done it plenty of times in little properties with little defects. And as long as
sometimes what percentage of these cases, would they go after then the listing agent too? I mean, you've seen that where then they like, they're a big brokerage and like they see money there, like, hey, we're going to go after the brokerage too.
Well, that's a really good point. So if they fail against the seller, it's sometimes easier to go against the agent because the agent has an errors and omissions policy, and those guys will settle just to get out of these things. Not always, but a lot of times. And so now you've got an easy, deep pocket to reach into. And sometimes the selling agent had the knowledge, and they can prove that the selling agent had the knowledge easy enough. I had another case where selling agent was on site while they were doing an inspection, and they talked about it was gas lines in the property, and the vendor came out, the gas installer, is a plumber, mechanical plumber, and they said, this whole house needs to be redone, and the seller had the direct knowledge. Now, if the seller never told the selling agent that all the pipes have to be redone, and the gas vendor told me this, now the selling agent can't be liable. But when the seller has knowledge they've conveyed to the selling agent, now the selling agent is bound by those same duties. And we'll get into a minute when that can create real conflicts. So the defect materially affects value. Let's just say that this is the second prong of the test. The defect materially affects value. $1,000 issue on $1 million home is not a defect that has to be disclosed. It's just not material. But a $1,000 defect on a $50,000 home probably is, or a $5,000 issue on $1 million. It's all relative. So there is no hard bright line rule, but certainly it has to be materially affecting value. So anybody that says you didn't disclose and you owe me all this money, if it's a small amount of money comparable to the sale, it's not going to be an issue. And I can give you a really, really good example of that when we're all done going through the three elements. The defect is not readily observable. A working definition of readily observable generally means a typical inspection won't disclose it. If the typical inspection won't disclose it, then it's probably not readily observable. So what don't inspections expose? We'll get into this one a little bit. So we had a property that we did. Actually, we weren't the closing agent, but we got the call. So the big expensive house in Wellington had a big, huge, heavy table. And in the dining area, there was a big, huge, heavy table. And underneath the big, huge, heavy table, there was a big carpet. And it was like a 10-person table with big chairs. And so an inspector would not walk through that property. And the inspector would not have moved that table and moved that big rug underneath, right? But when they came through for the walkthrough, there were huge cracks in the floor and the place had settled. And so now the buyer had legitimate concerns, and they brought up the disclosure issue, and it was easily proven that the selling agent was part of the team that put the carpet in place and put the table in place, and it was a giant mess. And so, yeah, it doesn't take much for the seller to go like, oh, the selling agent told me to do this, right? Roofers aren't going to take a dive for the seller, and the selling seller is not going to take a dive for the listing agent, right? And in that one, everybody was in on it, and it was a mess. And there was some recovery against the listing agent's errors and omissions policy. Most inspectors won't look inside walls, under the home, or above ceiling or crawl spaces, or do destructive inspections of any sort. I'm seeing now more and more, again, like Ryan said earlier, it doesn't hurt unless the selling agent or the buying agent has knowledge. But I have seen many situations, and agents call me up and they say, we know there's mold there, or this room got wet. And then the next thing you know, they don't say there's mold there. They say, we know the room got wet. But then the next thing you know, the buyer's inspector uses a little camera. It's on a microfilament, and they pull the socket off for the outlet, and they stick the micro camera in there, and they don't have to do any destructive testing. And now they're taking a little flashlight and they're peering around inside the wall looking for mold. And so when the agent knows that the property got wet, there's a protocol. We'll go over it in another podcast. Whenever you learn of water damage in a property, you want to get what I call the book. And the book it completely insulates everybody from liability. It's easy to get, and we'll go over an example of when the book is really important in a second. Sellers, and here's one that's really important before we get into some examples. Sellers can't just hire, I'm going back to the outline, sellers can't just hire another listing agent to conceal the facts unless they rewrite the contract. Use the contract in your favor. When you get that seller that says, oh, I'm just going to hire another listing agent, right? So you're doing a transaction, and the inspection report came over, and it has some defects that the seller knew about and they didn't disclose. And the seller just looks at the selling agent and says, I'm just going to get another listing agent. We'll go on to another buyer. I don't care. Let this one go. Let the listing agent go. Let everybody go. Now the seller has knowledge, right? It's in a document. And so as a selling agent, what you want to say to your seller is, that's not a great move. You have knowledge. I have knowledge. Any future transaction, they're going to know I was involved. First thing they're going to do is depose me or send me requests for admissions, and I'm going to have to tell them what I know. Mr. or Mrs. Seller, we just got to figure this thing out, right? It's either
give the credit.
Huh?
Give the credit to the buyer. Let's get this thing closed. You're going to have to deal with it regardless.
That's exactly it, right? I call it the buyer B syndrome. You're going to be dealing this with buyer B. You might as well deal it with buyer A. Get this thing closed, give the credit, do whatever. Again, now you have knowledge. If you fail to disclose that knowledge, you're liable to future buyers. So you might as well just do it now. And the future buyer, don't think they're not going to sue you if they learn they knew that you knew something and you didn't disclose it to the future buyer.
Yep. And as a listing agent, you just have the conversation, like, if they do dispose me, I have to disclose. I can't put my whole livelihood, on this issue. right?
But Ryan, what do you do when the seller says, well, I'll just go get another listing agent? What do you say?
I just tell them, like, this issue is going to come up with a new buyer. They're going to do the inspection regardless. And even if you do hide it and they do find it later, they can go back and, question everybody and dispose everybody if they knew it and still come after you and sue you.
And
Yep.
the topic is realtors getting sued.
I know.
And now Ryan has the knowledge, but the seller says, I'm not going to use you, Ryan. I'm going to use another selling agent. And Ryan, who doesn't necessarily still want to work for this seller, but Ryan's going to say, yeah, but if the future buyer has a problem, I'm going to end up getting deposed. Otherwise, I have to perjure myself and I'm going to be committed, I'm going to get in trouble myself. So I'm going to have to tell what I know.
Yeah.
So you might as well just A, work through the problem now with this buyer, and B, stick with me. All right, now I'm going to give you guys an example of a real case that happened, and it's a tough one. It's a disclosure issue. And I'm going to give you a hint. It's about the book that we talked about when there's a water problem. So there's a big, huge, fancy house, 2 stories, older couple. They lived on the first floor, several $1 million home. Well, not several, a few $1 million home, back when a couple $1 million was a lot of money, right? Before COVID. So on the second floor, older couple, they never go to the second floor. They have a shutter. The shutter has a bolt, and the bolt penetrates the stucco. And driving rain, the bolt rotted out. The water would go through the bolt hole and it went into the property. And over the course of many, many years, it rotted out the floor. The listing agent comes and they're going through the house and, oops, somebody raised their hand. Go ahead.
That's you, Jim. You raised your own.
That was me. That is me. And they're going through the house and the listing agent says, oh my God, there's been some water intrusion here. They can see the buckling in the plaster. They call a licensed mold remediator. They get a mold protocol. They get the mold remediation plan. They get a contractor to execute the plan, and then they do the post-remedial testing. So they've gotten what I call the book, and they can give that to any buyer if they decide. And now they have the perfect plan to a property that would otherwise have an issue. So now the property goes under contract. The listing agent does all this work. They didn't call me about doing the work. They were a sharp agent up in North County. They did this all on their own. Goes under contract. It happened to be a file we were closing. I get a call the day before closing, and the buyer's attorney calls me up at night and says, we're not closing. And we're going to sue the agent, and we're going to sue the seller. We're going to sue everybody. And you guys failed the Johnson v. Davis test. You failed to tell us about this material defect that affects value, and the seller had knowledge. Like, they did a beautiful job. You couldn't tell anything. Not only did they do a beautiful job on the work that was there, they upgraded the whole house to hurricane impact windows.
Wow.
My question to you is, what did I tell the buyer's attorney when I said, oh, the hell, we're not closing. We're going to closing, and if you don't show up, we're going to sue you for breach. Why did I say that? The property was the seller absolutely had knowledge, and it was not readily observable in an ordinary inspection. But the defect did not materially affect value. Why didn't it materially affect value? It didn't affect value because they got the book. They did the proper remediation, so there was no diminution in value to the property. Not only did they do the proper remediation, they actually improved the value of the property with the hurricane impact windows. Take the hurricane impacts out of it, they still didn't owe the buyer a disclosure. So the realtor calls me up. I was really good personal friends with the agent. She calls me up. She goes, you're going to get a nasty call right now from the buyer's attorney, and they're not going to close. And when I told her about the materially affecting value issue, she sighed a sigh of relief. She breathed a sigh of relief because instantly she got it. There was no diminution of value.
Was this a case of the buyers just wanting out of the deal because they found a better deal or something? I mean, or was
could have been. Who knows? Could have been.
Wow.
But change the facts a little bit. I did a house in Lake Worth, a cheap house in Lake Worth, where the seller went and this was at the advice of the agent. The agent's wrapped in, right? So this is the piece for agents, don't get sued. The agent said, I have a handyman. There was some water infiltration. The agent said, I have a handyman. They did the work. And then the handyman wasn't a licensed mold remediator, didn't have the book with the protocol and the testing and all the things you need to satisfy the buyer. And so the buyer on the walkthrough went through the property and saw there was some buckling in the floor where there was a throw rug before in front of a window. They took their little probe and they pulled off the outlet cover and they saw the mold and they dug up the walls. Why was the seller liable in that transaction and not liable in the first? Because in that transaction, the seller didn't have a licensed mold remediator. The realtor told them to use their handyman. And so now there was a diminution in value because they couldn't prove that everything was restored perfectly. They didn't have mold tests before and after the loss. They didn't have a protocol, and it wasn't done by a licensed mold remediator. So there was a diminution in value because they did a defective repair.
Who did they sue? I mean, what happened? They just let him
Oh,
on.
they sued, it was an easy one. They went after the seller, and then the seller went after the agent. And they recovered against the agent.
So they went after the agent's errors and omissions and insurance.
They went after the agent. I think they recovered under the errors and omissions. Why did they go after the agent? Because the agent said, here's my handyman.
Mhm. I know it's like you know, you want to do good for your clients and recommend good service providers, you know, but as we've discussed before, you know, it's better to suggest 3 of them, right? And say you pick one, right, Jim? Isn't that the best way
And
to
if
do
you
it?
have an issue that's going to be a water issue, that could be a mold issue, you got to use a licensed mold remediator. You got to give 3 referrals, and you got to, you know, you got to use a licensed person. I mean, here's the reality, right? Florida is tough. If you take apart the plenum in any air conditioning unit in Florida that's more than 5 years old, you're going to find mold, right? So there's mold in every house. If you pull the baseboards back in any house that's slab on grade construction, you're going to find a little bit of mold behind the baseboard. Period. End of story. Does that mean you hire a licensed mold remediator in every single situation? No. You have to exercise common sense. But the reality is, if you go to Italy, every house in Venice has mold and nobody complains because it's just such a common thing. Here in Florida, there's no great mold conclusive litigation, but everybody's up in arms over it. You have to use common sense. I mean, I have seen some disastrous situations where realtors gave bad advice, but I also thought it really wasn't much of an issue. Where you have a blend line between an attic and a living space, so the living space is cooled and the attic is hot. Sometimes if it's not insulated well, you'll get mold around that attic cover. I saw a situation where the buyer wanted to make a stink and it cost the seller $6,500 to remediate that little molded area around the attic scuttle. You just got to use common sense. I mean, I've seen some situations where realtors sent me pictures of attics, of ceilings in garages where the whole ceiling's covered with mold, and they're going in there and they're painting over it, not disclosing it. I mean, it's just an accident looking for a place to happen. You got to use common sense. Misrepresentation, I think we've beaten that one to death enough. If you have questions, though, you have corner cases, tough questions, give me a text. I'd be happy to answer. Misrepresentation, providing false information about a property, know the facts. So you're providing false information, right? The easy one is know the facts, review the property appraiser's record. What's the zoning and the land use? The easy stuff. Don't mess it up. What do the available public records reveal? The big question is, how far do you have to dig? The general rule is I would dig far enough to make sure you're getting your commission. Dig far enough to make sure no one's going to complain and you're going to close, right? So if you walk into a property and they tell you it's a 3-family, I had one the other day, 2-family property, look at the property appraiser's record, make sure the card says multifamily. If it says single family and you're listing it as multifamily because the seller tells you it's multifamily, you're going to have a problem. And you're not going to get your commission. So do enough research to make sure you get your commission, and you're not going to have the problem, right? If you're selling multifamily, make sure it's multifamily. This one came up recently, and I told the seller called me and I said, listen, you're going to have this problem with everybody in the future. deal with it with this buyer. Cutting your listing agent free isn't going to solve the problem. I'm going to just go get another listing agent. They all tell me the same thing. I'm going to go find another listing agent. You're just going to have this reoccurring issue, and you've been breaking the law for years, and now you got caught. Sellers don't like to hear it. They don't like the fact that they're getting a lot less money, but the reality was the lender wasn't going to lend because it was a single family except for a certain amount of money. And they, lending controls the purchase price, period, end of story. If you go into a property, we had this one the other day, and the property got listed as a multifamily and it was a converted garage. If you go into a property and you're taking a step down,
I know it's a dead giveaway.
to go into a living space and there's a huge sliding door where a garage door was one time, don't list it as a 4-bedroom. This came up and the lender lent on 4 bedrooms and everything was contingent on 4 bedrooms and 3 bathrooms, and it was a 3-bedroom and 2-bath. Period, end of story. There's nothing you can do about it. The devil now is going to be better than the devil that comes up later. Title Advance, we have a product, Title Advance IO. It won't keep you from getting sued, but it will help you make sure you're getting your commission as quickly and as smoothly as you can, regardless as if you're buyer or a seller's agent. I'm seeing lots of buying agents using title advances now as we're talking. I'm seeing them actually coming up, and buying agents are using title advance. Buyer's agents are using title advance to figure out what the defects are on the property before they make offers, setting their buyer's expectations. The buyer wants to close quick. They're using title advance to make sure they can close quick. We can go into that later. Breach of fiduciary duty. Failing to act in the best interest of the client. You're a buyer's agent. You just learned something. Ooh, you just learned something. You just learned something about the property that can hurt the sale, and you don't want to tell your buyer. Revert back to the common sense rule. You don't want to get in trouble. The devil now is better than the devil you have to learn about, that your client's going to learn about either right before the sale or after the sale. Just get it on the table. Realtors are not a party to the contract. We talked about the contract earlier. Realtors are not a party. They're not bound by the terms of the contract in general. They have some duties created under the contract, but the contract is between buyers and sellers. Dual agency conflicts. These are the biggies. You represent both sides. You learn something that's damaging to the deal. What do? Common sense. Disclose, disclose, disclose. You got to disclose it in writing. Anything you learned about prior to the contract from the seller, you don't want to say it, but you just got to disclose it when you finally get a buyer. You're a dual agent. You have a fiduciary to both simultaneously, and that's when realtors get in trouble. And it all happens the same way. I see the requests for admissions, and they go over, and realtors call me and they say, "Hey, can you represent me in this lawsuit?" Or they're defending themselves against the buyer, and they say, the first thing I said is, "Did you have knowledge?" And they reluctantly, 9 times out of 10, say, "Yeah, we had knowledge." So if you know something in a dual agency, you got to disclose it. The general rule of thumb is you're a conduit, right? You're a conduit. You transfer the knowledge. Whatever comes in goes out to the other side. You disclose it in writing. You disclose it as quickly as possible. Don't sit on it, and make sure you have no reason for the other side to come up and say, "Oh, they concealed," right? They concealed the knowledge until right before closing when we were in a bad position, and now we had no alternative but to close. Have you seen one of those, Ryan? I saw one just the other day.
Yeah, special assessments, seen that, pop up. I've seen, where that wasn't disclosed. Of course that's going to pop up. You know what I mean?
Yeah. So there's one that's public record, right? The seller's not under a duty, but there's a good reason to disclose it early on.
Yeah.
If there's a pending special assessment that the seller has knowledge of, it's going to derail your transaction in the last minutes of the deal when the title agent finally gets the file together. Get it out in the open. And more specifically, I'm talking about things like a vendor. I saw one recently where the vendor told the realtor something. The realtor was a dual agent. It was an AC vendor, an AC contractor, and the agent sat on it to the last minute. And the agent called me early in the deal and said, "What do I do about this?" As a young guy, he'd been doing real estate not very long, and I said, "You got to get it out in the open early." So what does he do? He sits on it to the last minute. you know, maybe it was green, maybe he wanted to lever people into a closing, and then he disclosed it and everybody's upset. Dual agency conflicts are huge, and you got to make sure you make those disclosures in writing. If it's going to affect the deal, get it out in the open early. Other times, buyers and sellers may sue their realtor. Agency, we talked about this a second ago. Make sure that you're the conduit, not the originator of opinions. You're just the conduit. Here's 3 referrals. Here's what I've seen happen in the past, but you got to talk to your CPA. Here's some general guidance, but you're not the expert. Here's what you're in an agency, you're in a dual agency agreement. Here's what the buyer said. Here's what the seller said. You're not coming up with new ideas. How to incorporate your business to reduce liability. There's a misconception that incorporating eliminates liability. Incorporating eliminates transactional liability, but it doesn't eliminate negligent liability. What do I mean by that? If you're a corporation and you hire somebody to paint your house and you don't pay your bill, then they can only sue the corporation, right? The corporation owns the house, you hired a painting contractor, and Ryan owns the corporation 100%, but the corporation was the party in the contract. The painter can only sue the corporation. The corporation doesn't have any assets. The suit's pointless, right? But if Ryan sets up a trap at his house, a trap is a legal term for creating something that people aren't aware of that's dangerous, and the painter falls into the trap and gets hurt, liability isn't just contained at the corporate level. Liability can go to Ryan personally. Same thing with realtors. If you're a corporation, you're a PA, you're an LLC, and you commit a misrepresentation or a negligent act or a willful or wanton act, liability will get to you personally. And there's a big misnomer, and I've seen tons of podcasts on YouTube and discussions about, oh, avoid liability. If you're negligent or you had a duty and you breached the duty, you can't hide behind your corporation. So that is a misnomer.
Baby.
Say that again?
I think Jeff. Hey, Jeff. I know. Did you have anything to say, Jeff?
No, I sneezed. I'm not on.
There you go.
All good. Know what a release and cancellation of contract includes and when to use it, right? Release and cancellation of contract in every single transaction that doesn't close or everything you agreed to close. It doesn't matter how much everybody expects. It doesn't matter about the exchange of emails. Get a signature from your buyer, get a signature of your seller. I see so many deals over the years where people call and they say, oh, we thought the deal was dead. One person thought the deal was alive. That's a big source of liability for realtors. If your deal is dead, kill it with a cancellation of contract. Don't assume. Inspection periods, communicate in absolute position. You can't have your cake and eat it too. So when you're writing addendums, you can't have your cake and eat it too, right? You're talking to your client. I don't even want to see a show of hands. Nobody's ever going to say, right, in a text or something that the buyer wants to kill their contract. Everybody's going to send over a cancellation of contract signed by your buyer, right? You don't ever want to be communicating your buyer's position. You want to be the conduit of your buyer's position with the document signed by your buyer. But what I've seen recently is deals are getting harder, right? And so you got a buyer that wants to cancel, and you got an agent that's representing the buyer, and they want to send over this cancellation, but they kind of hedge around the whole thing. No, it's your buyer cancels, but we'd be happy to reignite the contract if the seller is willing to do this. You know, I get the call at 11 o'clock on the last day of the inspection period, and the realtor is agonizing over what to do. You have to cancel. Period. End of story. And then you got to revive the contract by saying, here are terms that are acceptable to us. The other thing you don't want to do is you don't want to send the text over, like I said a second ago, the buyer wants to cancel, right? That's a nothing. That's an opportunity for a realtor to get in a whole pile of trouble.
Yeah.
Right. So you want to be the conduit. I saw an addendum recently, 20-year realtor. There was no firm communication of a position who was responsible and no drop dead dates. Terrible, terrible, terrible. You gotta communicate action steps that when anybody reads it, they know what to do. A proper addendum is a mini contract, and all real estate contracts must have a minimum of 4 elements.
Yep.
Parties, place, price, and time, right? So if you're writing this addendum, like the one I saw, where it was, these things are supposed to happen and there's no time frame with which they're going to happen by, and there was no great assignment as to who was going to do it, right? The assumption was, because it was in the inspection report, that the seller was going to do it, but they never specifically said the seller shall before closing do the following. It just said the inspection report revealed this, and you know, this is going to be taken care of. You got to be very specific. Do not make yourself the expert. This is what Ryan was talking about. Give 3 referrals. So I had a realtor the other day, and they were talking about some pretty complex taxing issues. They want to know how they should handle it. I said, absolutely refer them to 3 tax strategist specialists. Do not give those opinions. And then the last thing I wanted to do not be the expert giving those opinions. And then if they don't go out and use your referrals or find their own experts, that's their fault, but at least you made them in writing. And the last thing I want to talk about was read your contract. If you read your contract once a month, 2 or 3 times today, and once a month, every month that you practice, you'll be the expert. You will not get in trouble. You will get yourself out of most of the problems that you could get yourself into. And that's your best shot at avoiding liability, is knowing what you're obligated to. All right. Does anybody have any questions? Oh, we got a nice little group here that amassed while we were while I was focusing on the outline. We got anything in the comments? We got 13 participants. Nothing in the comments. All right, Ryan, you want to wrap this up?
No, it was great, Jim. You know, thank you so much for sharing all that information. Being an attorney, real estate attorney for over 30 years, you've seen a lot of it, and sharing that information with agents. Also, to agents, if you have any, you know, webinars that you'd like for us to host in the future, feel free to put those in the chat as well. But yeah, Jim, you did a great job. Thank you so much. You know, I've had
Thanks,
a lot of those issues come up in my own career, you know, throughout it too. So just a quick thing here, you know, I'm an agent myself, been doing this for over 20 years. Like I said, I'm in the trenches with you all. About 2 years ago, I launched an awesome real estate company called RealTrade. It's an online marketplace and social media platform for real estate. It's a great way for agents to connect with buyers and sellers. The cool thing is it's free for agents. And not only can you connect with buyers and sellers, and they can connect directly off your own listings, you can connect with service providers like Jim and other lenders like Jeff Stewart here that we have on the call that are on the platform that can help you with your needs in your as you go through your real estate journey. So Jim likes to say we're the home of the double dip. You own your own listings, you own your own leads on RealTrade. So that's a big one.
You're building your brand for free, right? The only thing you're spending is time. You go to build your brand on any other platform, they're going to rob you. It's a crime. In my opinion, it's a crime, right? You go out, you talk to sellers, you find your listings, and then you use a tool like one of the competitor platforms, and you're paying, and you're actually getting all kinds of people robbing your lead. And now you got to pay to actually be the top person on your lead. It's terrible. And I love hearing about the stories where people are getting the sales on RealTrade, unlisted properties. Buyers are going up there and saying, I'm looking for this, and then it results in a contract. I love those stories.
Yeah, we got thousands of buyers, sellers. We have just cracked 1,700 agents and a lot of great service providers.
Yeah, baby.
But I do want to have a good thing here. Shout out to you, Jim, because, you know, having been an agent, I've used a lot of title companies. New Path Title, okay, with their closing software, Title Leap, is one of the, like, a game changer. You know, I'm a pretty active agent and closing deals, and you know, you need like a contract coordinator at some point. Things get so busy, but having Title Leap and using Jim, you know, where they keep track of all your drop dead dates is amazing. And then taking advantage of, which is a big one, is Title Advance, which is a free service that they're now offering, you know, agents. Jim talked about it. You can actually order that through RealTrade right under your dashboard, which is awesome. But I tell you what, it would have saved me on a past deal 2 years ago, $6,000 that came out of my commission on the sale, because there's this crazy lien against MV Realty, if you've all heard of them. I would have known about it before I even took the listing, and I would have saved myself so much headache and basically worked for free. So, you know, there's a lot of value in Title Advance using that and having no surprises. So,
and when we invented Title Advance, we thought it was just going to be a seller's tool, right? Seller's tool to win listings and seller's tool to go out there and know exactly what the closing was going to look like. But the reality is I'm hearing buyer's agents use it. So buyer's agents are using title advance. They get a buyer and they say, oh, our kids have to start school in 2 months. So they're only making offers on properties that qualify to close quickly. If they see there's any hair on the deal, they're not making offers on those properties. And you can go into paragraph 20 in Palm Beach County and you can write the closing agent shall be New Path Title. You can still have the seller paying for title. Doesn't mean we're going to get the deal, but you can call, get a title advance, and you can learn about the property. When you make the offer, in paragraph 20, in the comments section, additional terms, write New Path Title shall be the closing agent, capital C, capital A, that's the defined term in the contract, and then the seller's still going to pay for it, but we'll close it for you. And now we have advanced knowledge of the title. So we're going to get started on the transaction that much sooner, and we'll have a relationship that much earlier in the deal. The other thing is we have a law firm standing by 24/7 to take on evictions or ejectments or unlawful detainers or partitions or anything that may come up. You get clients and their partners that have property. One wants to sell, one wants to rent. There's ways that we can deal with them very quickly. And I offer 24/7 attorney support. So if you want to text me, you can go to New Path Title. You can click on 24/7 attorney support and you'll get me and we can talk through whatever the issue is. While we were on this podcast, I got a couple of texts from agents, and as soon as we get off, I'm going to respond to them and we're going to try to get them under a contract.
And Jim's awesome. I mean, I've texted you, Jim. I don't want to give out too much, but I've texted you like 7, 8 o'clock at night on just a quick legal, viewpoint that I needed for my clients, and Jim responds right away. It's pretty awesome.
9 times out of 10, my response is going to be line whatever in the contract, but there's a bunch of stuff that comes up. 9 times out of 10, the answer is in the contract, but I'm happy to get really focused on the right deal. But it's a lot of fun working with you guys, right? This is the best part of my day. So don't spoil it for me and keep those questions from coming in. All right, you guys, that's all I got. We're exactly a minute. What are we? An hour and a minute.
A little over an hour. Yep. It's perfect,
Yep.
Jim. Good job.
All right, you guys, we'll see you next time. Text me with any stuff you want to cover. Tanya, it's always a pleasure. And Jeff, and it's nice to see a bunch of new faces in here, and we appreciate you.
All right. Thanks, Jim. All right. Bye.